Welcome to the inaugural high school moot court in Ohio. I'm Stephanie Bucher with the Ohio Supreme Court's Office of Public Information. We're coming to you from the Thomas J. Moyer Ohio Judicial Center in Columbus, where more than 70 students from 13 high schools will be participating in today's event. Moot Court is a program of the Ohio Center for Law-Related Education that focuses on the appellate court process, an often misunderstood part of our judicial system. The 2014 Moot Court case, Charlie Charleston v. State of Ohio, centers on the Fourth Amendment, which is the right against illegal search and seizure, and a hypothetical stand-your-ground Ohio law. In this year's case, a high school student arrives at his parents' house at night and sees a stranger approaching as he gets out of his vehicle. As the stranger gets closer, the student begins to feel threatened, draws a gun, and shoots and kills the stranger. When police arrive, they search the student's car and discover incriminating material. The student is ultimately convicted of second-degree murder, and in his appeal argues he acted in self-defense and that police violated the Fourth Amendment in the search of his vehicle. Moot Court incorporates both written and oral argument components. The students have submitted their written briefs in which legal issues of the case have been presented. And prior to the competition today, the students' written briefs were reviewed and scored by a panel of volunteer attorneys. Today, 16 teams will present oral arguments for both sides of the case against other competing teams. A team consists of 2 student attorneys and a timekeeper. The written briefs are judged on a number of different components, including organization, grammar, analysis, and persuasiveness. Arguments are evaluated on the application of the law to the facts of the case. Now, by focusing on the applicability of constitutional law to current legal issues, Moot Court offers the students an opportunity to develop an understanding of the Constitution and the judicial system while strengthening their writing, speaking, and critical thinking skills. And if you would like some more information about this program or any other by the Ohio Center for Law-Related Education, you may visit their website at oclre.org. Now, let's watch as our students present their arguments in the Moot Court 2014 state competition.
Would the appellant introduce themselves?
My name is Kaylee Klein, and this is my co-counsel, Morgan DeWitt.
And you're representing which?
And we're representing the defendant appellant, Charlie Charleston.
Thank you. Appellee?
My name is Meredith Arn, and this is Haley Walker, and we are representing the appellee.
Thank you. Appellant ready to proceed?
Yes, Your Honor.
Timekeepers ready?
Okay. Good morning, Your Honors. Today we'll be addressing the issue of stand your ground. Your Honors, may it please the Court. This is a case of immunity. The series of events that occurred on the 15th of December occurred in this order. A young man arrived home. An unidentified masked man proceeded to approach him aggressively, and the young man, having no choice, lawfully shot his assailant as justified under the Stand Your Ground statute. This is not a murder case. This is an immunity case. The defendant appellant acted lawfully, leaving him immune from criminal prosecution and arrest. The process that took place on the night of December 15th was incorrect and unlawful. We submit that the defendant appellant, Charlie Charleston, acted lawfully under statute RC 2999-16. Before looking at Ohio's Stand Your Ground statute, we must first turn our attention to the case Estate of Heinzelman v. Air Experts. This case establishes that the language of a statute, when a language of a statute is clear and unambiguous, that it's the duty of the court to read the statute plainly, making no additions or subtractions. A plain reading of the Ohio Stand Your Ground statute allows for a defendant to use justified deadly force when they feel that there is a reasonable fear that they have to use it to protect themselves from imminent death or great bodily harm. There are 3 things that happened that night that would meet the requirements under the reasonable fear. The assailant was hiding his identity from the defendant appellant. He was wearing dark clothing and a ski mask covering his face. He was wielding a large object in his hand, and he was aggressively shouting as he approached the defendant appellant. This is a case of first impression. There has never been a case tried like this in Ohio before, and there is no precedent to rely on.
Is the statute reliable?
Yes.
Okay, well, why can't we just rely on the statute?
We would be relying on it if you read it plainly and allowed for the defendant to meet the requirements.
And we should ignore all Florida precedents?
Yes, as the statutes are not the same, they just mirror each other. There's a few main differences between the statutes, as the Florida statute defines criminal prosecution and the Ohio statute does not. The Florida statute also will award reasonable attorney fees if the court finds that the defendant is immune from prosecution. Because these statutes are not exactly the same, you cannot rely on the Florida precedent of Dennis versus State of Florida to make a decision in this case.
So what did the trial court do wrong when it read the stand your ground statute?
It determined that the defendant did not have a reasonable fear, and they did not read it plainly, as they did not allow for the defendant to act lawfully, and they did not conduct a pretrial hearing to determine if he had a reasonable fear established.
Was a hearing absolutely necessary?
In this case, it was, as there are no previous cases to determine this, and there is no way to tell whether or not he did have a reasonable fear without knowing before the trial. If he did have reasonable fear, there is no reason that he should have gone to trial, because he was immune from prosecution and arrest.
Does the statute require a hearing?
No, the statute would have already allowed him to be immune, and there would have been no reason that he would have been taken to court if it would have been followed properly.
Okay.
But isn't that why you go to court? Is to have the judge, who is the final arbiter of what is the definition of the law and the standards, make that decision?
Yes, but because it was already established that the stand your ground is, because the stand your ground is already there and in place, they shouldn't have gone to court because he was already immune from the case, and prosecution should not have occurred. And because of the requirements set forth in RC 299932, he should have been immune from the prosecution because there was a preponderance of evidence that allowed for the reasonable fear requirement to be met. At this time, we respectfully ask that you reverse the ruling of the trial court. Can I sit down now? Okay.
Thank you.
Good morning, Your Honors.
Good morning.
Let me introduce myself again. My name is Morgan DeWitt. The issue before the court regards the search of the defendant appellant's iPad. After analyzing the concerns of the search of the iPad, we submit that the search was done unlawfully. Your Honors, may it please the court. The search of the defendant appellant's iPad was done unlawfully under the Fourth Amendment. The Fourth Amendment specifically prohibits unwarranted searches. A warrant was never obtained to search Charlie Charleston's car, even though the officers had plenty of time to receive one. The defendant had been placed under arrest, put into the police vehicle, and the scene was secure.
Isn't a warrant unnecessary because the search was incident to a lawful arrest?
Can you repeat the question?
Isn't an arrest warrant unnecessary because the search was incident to a lawful arrest?
I believe that the lawful arrest was not lawful. I think that under the stand your ground that it was an unlawful arrest.
But what if, assuming that the arrest is lawful?
No, because they had no reasonable suspicion that there was anything that they could uncover from the car that they would find evidence towards the shooting. May I proceed?
Please.
The The police had an ample opportunity to obtain a search warrant, and there was no excuse to do a search without one. As originally written, the Fourth Amendment requires a warrant for all searches. In application, several exceptions have been established. One of these exceptions is exigent circumstances. We submit that no exigent circumstances existed, thus the search of the defendant appellant's iPad was in violation of his Fourth Amendment rights. It is true that the iPad was found near the gun inside the defendant appellant's vehicle, but we offer that there was no reason for the police on the scene to believe that there was a connection between the iPad and the death of the Max individual. The Supreme Court has clearly stated that there is a higher level of privacy that goes along with the searches of electronics. In State v. Smith, the defendant was convicted of selling crack cocaine. After arresting Smith, the police proceeded to search him and retrieve his cell phone. The search of Smith's cell phone was done without his consent. After sending the case to Supreme Court, the decision was made. The Supreme Court held that the search of the cell phone records was not necessary for officer safety, and there was no immediate threat that any information could be deleted from the cell phone. The court wrote that because a cell phone is not a closed container, and because an individual has privacy interests in the contents of the cell phone that goes beyond the privacy interests in an address book or pager, an officer may conduct a search of a cell phone conduct a search of a cell phone's contents incident to a lawful arrest without first obtaining a warrant. We submit that the same ruling should be applied in this case. Although a cell phone and an iPad are not the same thing, they can be used interchangeably. An iPad has the same capabilities to make phone calls, send text messages, send emails, and store information as a cell phone. Cell phones and iPads should be treated the same under the Fourth Amendment.
Don't iPads have additional qualities, characteristics than a cell phone?
They do, but you can get like a data plan that can make it so that it's almost exactly the same as a cell phone.
Almost exactly, but
Yes.
not exactly.
Not exactly the same, but close to it.
Okay, so, but the police officers had no idea what type of data plan the iPad had, correct?
Correct, but they should have gotten a warrant and seek that information before they searched it.
Did they need a search warrant to get the gun that was sitting there?
I believe that they did because they were not at the scene at the time of the shooting, so they had no idea what was in lunge reach during this scene and what he used exactly. May I proceed?
Please.
Charlie Charleston's case is no different from Smith's. The defendant appellant did not give the officers consent to search his iPad. The defendant appellant never made any immediate threats to delete any information from his iPad. Neither did the iPad ever offer any immediate danger to the officers who conducted the search. Not only was the iPad not offering any immediate danger, the police had no ability to know if the iPad was present when the shots were fired because the defendant appellant left the scene. The argument that the iPad was not password protected is not relevant in this case. The fact that the iPad was not password protected is not an invitation for the police to enter. If the police go to a front door, ring the bell, and the inhabitant of the house answers the door, there is no assumed right for the police to enter the house. The privacy of the defendant appellant still exists without it being established electronically by a password.
But houses are different items, correct, under the U.S.
Correct.
Constitution?
Yes, but under the Fourth Amendment, it says that, in one of the cases, a justice said that the Fourth Amendment does not protect places, it protects people, and an iPad and a house both don't fall under people. So
Well,
they're similar.
iPads aren't people either.
No, so the iPad and the house. Can you repeat your question?
Yeah, I just said iPads aren't people either, are they?
No, but they still should have gotten a warrant to search it because it's part of Charlie Charleston's privacy.
Privacy, even though he didn't have password protection.
Yes.
Anybody, if he left that on a table, anybody could pick it up and just start using it, right? Go online and search Google, do emails.
Yes, but in a legal sense, it was not right because they should have never, like, they should have never even obtained the iPad. They should have left it alone.
Okay.
May I proceed?
Please.
The privacy of a defendant appellant still exists without it being established electronically by a password. That is comparable to an officer being able to search your body without consent after being pulled over for a speeding ticket just because you look suspicious and your body does not have a password. In Schimmel versus California, the court reasoned searches incident to arrest are limited to the area within the immediate control of the suspect. While the police could search Charlie Charleston's person, they could not search his car because it was not in the area within his control after he was secured by the police. The exception to the Fourth Amendment, where officers can search items that are in plain view, also does not apply to the iPad because the information on the iPad was not in plain view.
And didn't the officers testify it was?
Well, the information on the iPad was not actually in plain view. They had to go through it to find his documents. It was lit up, but to get to his list that was on the iPad, they would have actually had to click my list and go through it.
Okay.
I thought they tested, I'm sorry, go ahead.
Thank you, your time. Thank you.
Oh, thank you.
Thank you. Please. Please proceed.
Good morning, Your Honors, and good morning, Counsel. Again, I am Meredith Arnn, and this is my co-counselor, Haley Walker, and we are representing the appellee. The appellant, Charlie Charleston, was arrested and charged with first-degree murder and then proceeded to file a motion to suppress and another to dismiss, both of which were denied. He then went to a bench trial where he was found guilty of second-degree murder and then appealed, but the Circuit Court of Appeals affirmed the decision of the lower court. May it please the court, we ask that you uphold the decision of the trial court to deny the motion to suppress the evidence obtained from the vehicle, as I address what the appellant believes to be the first assignment of error. The Fourth Amendment of the United States Constitution states that it protects citizens from a reasonable search and seizure without a warrant. While this is in the United States Constitution, exceptions have been carved out over time. In this case, upon return to the scene of the crime from a friend's house where he called 911, the appellant was taken into custody and put in the back of a police cruiser where he was interviewed about what had happened from his view, and the decision was made during the course of the discussion to place him under arrest and not permit him to return to the vehicle. After placing him under arrest, they conducted a full search of the vehicle. The case Schimmel v. California says the court decided the police may search a lawfully arrested person and surrounding area for hidden weapons or evidence that may be destroyed without a warrant. This is valid for the case because car isn't a secure place. Windows can be broken, what if the door is not locked, and there are multiple sets of keys.
Well, he was, Mr. Charleston, he was in the police vehicle, correct?
Yes, but he had left the scene earlier to go to a friend's house, so it was evident that somebody else had known about the events that had taken place.
But when the search actually occurred, he was in the police car.
But with the case Arizona v. Gant,
Yeah?
it was found that officers may search the vehicle of a person who has been detained, as Charlie Charleston was, and is not in the vehicle if it's reasonable to believe that it contains evidence pertaining to the case.
Well, they saw the gun, right?
They didn't, the gun was said to be in plain sight along with the iPad.
Right.
And on top of that, they had knowledge of the gun from, first off, knowing that the body had been shot, and also that he had been in discussion with them when they placed him under arrest. So he had told his side of the story, and I would believe his side of the story would have the evidence of the gun also.
But couldn't the police officers have placed an officer outside the car to make sure nobody messes with it while another officer obtained a search warrant to search and to seize and search the items in the car?
Even if they did, it's still unsafe for the iPad itself, because an iPad is not supposed to be left in severe cases of heat or cold, and the iPad, in essence, could be broken. Therefore, the information could be lost, and they wouldn't have had the information at all. Whereas if they would take the iPad from the car, as Arizona v. Gantz lets them, they would have the iPad.
What reasonable belief did the police officers have that the iPad had anything to do with the crime, the alleged crime?
I believe that they had The iPad was near the gun, therefore they believed it would have connection to the case. And it was in plain sight for the driver himself, so it was obvious that it wasn't just it wasn't set to the back where he wasn't using it, it was in the front where he could reach it very easily. While conducting the full search of the vehicle, the gun was found sitting in plain sight on the passenger seat, and the iPad was turned on but not password protected, lying on the floorboard on the passenger side. After opening the iPad, the officers found a document titled My List, containing a list of classmates in ways they could accidentally disappear. The question at hand isn't whether or not they had the right to obtain the iPad, as much as if they had the right to open the iPad. While the appellant believes the officers didn't have the right to open the iPad without a warrant, and therefore the information should be suppressed with the jurisdiction of State v. Smith, which found that the state may not invade a cell phone without a warrant because a cell phone's storage capacity creates and justifies a high expectation of privacy. While at first this seems like a valid argument, an iPad isn't in fact a cell phone. Therefore, it doesn't support the appellant in this case.
You heard the appellant's argument that it's all but the same. Isn't it?
Yes, it says the argument was made that the iPad was able to have all the capabilities of a cell phone, but without Wi-Fi or data capabilities, an iPad is just an electronic notebook.
But how would the officers have known that? They wouldn't.
They wouldn't know that.
I would assume that somebody's iPad contains everything that's important to them on it.
But at the same time, the appellant had given up his right to privacy by not putting on a password.
Did he give that up to the state by not password protecting his iPad?
I believe he did, because every iPad owner has the right to go into their iPad, click on their settings, and set a password. They can put a word password. They can put a number password. There's so many capabilities for a password, and you could have so many different passwords. And by not putting on a password, he gave up his right to privacy to that iPad. For I could go up and pick up an iPad off a table that's not password protected and just open it and go through it.
Yeah, but you're not the police.
But the police could also do that. Without the warrant, he gave up his right. They would need a warrant if there was a password, because he gave up his right to privacy at first by not putting on that password. But if there were a password, I believe there would need to be a warrant.
Well, by definition, they couldn't get into it otherwise.
But by not putting on the password, he did give up his right to privacy to that iPad, and he left it open. Without the network connection capabilities, the iPad's just a high-tech notebook, and the iPad wasn't password protected. In search of the vehicle, police are allowed to search in a closed container, such as purses, bags, or notebooks. And without Wi-Fi, I am in essence talking about the closed container being an iPad, because without the network capabilities, the iPad is just a notebook waiting for somebody to open it or pick it up, because the passwords are to protect them, and by not putting it in, he gave up his right to privacy. Therefore, I believe it's reasonable for the police to open said iPad.
If a cell phone, which you will concede is protected, a warrant is required to look through a cell phone, correct? If the cell phone doesn't have a password on it, is it fair game for the police officers to look through it?
It's not fair game for the police officers to look for a cell phone due to State v. Smith that states that it has a high expectation of privacy for its capabilities. But the precedent hasn't been set for iPads yet on whether or not the iPad is under said qualifications of State v. Smith.
So why shouldn't we set that precedent today?
I believe the precedent shouldn't be set for iPads do have the capabilities to do the things as cell phones, but only with network capabilities. And this isn't the case all the time. And iPads are just an electronic notebook without the capabilities of Wi-Fi or data. For the reasons I have discussed, I ask that you uphold the lower court's decision to deny the motion to suppress the evidence obtained from the vehicle. If there are no further questions, I ask for my co-counselor to come forth and discuss what is qualified what the appellant believes to be the second assignment of error in this case.
Any further questions, judges?
No,
No further questions.
Thank you. Good morning, Your Honors. Good morning, Counsel. My name is Haley Walker, and I'm representing the appellee side.
I'm here to prove to you that the decision of the lower court to convict Mr. Charleston should be affirmed for the following reasons. May it please the court, the Ohio legislature's creation of the Stand Your Ground statute was put forth to allow a person to protect themselves against harm by using force, that is, except for deadly force. The appellant did use deadly force when shooting the victim with the gun. The appellant knew that his weapon was superior to the victim's weapon.
How did he know that? What's in the record to show that?
In the record, it is stated that the victim's weapon was a plastic shovel and the appellant's weapon was a gun. And due to the case State v. Roberts, we have to accept the facts of the lower court.
Thank you.
Therefore, the use of deadly force was not protected under the Stand Your Ground statute, which states that deadly force is justified when the person being attacked has reasonable belief that the other person will cause great bodily harm or even imminent death.
So if somebody's coming up and going to hit you with a shovel, that's not deadly force? You ever think somebody get hit in the head with a shovel, it might kill them? Isn't that reasonable?
Due to the fact that the shovel was plastic, it is not reasonable to believe that it would cause great bodily harm or imminent death.
Is it reasonable to expect Mr. Charleston to make that assessment in the heat of the moment when the shovel is coming at him in his mind?
Technically, according to the facts of the lower court, the appellant wasn't coming at or the victim was not coming at the appellant. And when the appellant told the victim to stop or he would shoot, the victim slipped and fell, and that was when the appellant shot the 2 rounds into the victim. The victim also never yelled anything that would lead the appellant to believe that he was in immediate danger and that harm would come to him. He simply said, "Hey, you," which is something very common and typically used between friends. So it's not reasonable to believe that the appellant felt immediate danger based or as a result of the presence of the victim.
Wasn't the victim wearing a ski mask? So
Yes.
his face was covered?
The victim was wearing a ski mask, but seeing as it was the winter because snow was laying on the ground, it is also reasonable to believe that the victim was only wearing a ski mask because he was trying to keep himself warm from the
Oh, I
cold.
agree with that, but looking at it from Mr. Charleston's perspective, someone with a ski mask on, yelling at him and coming at him with a shovel, I don't think he cares whether he's wearing the mask because of the weather or whether he's wearing the mask because he doesn't want his identity known. Isn't that reasonable for him to have thought?
It's not reasonable to believe that he was necessarily coming after him in a threatening way just because he had the ski mask on. Just because in the past it can be a negative reputation for a ski mask and could mean something bad. Though it could be frightening to the appellant, the victim didn't yell anything at the appellant that could make him believe that he was going to harm him. By saying this, I am not stating that the person has to wait to be harmed, but saying that they have to have reasonable belief that imminent death or great bodily harm is to come to them as a result of the situation at hand when using the deadly force. And in this case, reasonable belief is not evident. The Ohio Stand Your Ground statute is new, and therefore it is unclear and ambiguous. For this reason, we look at the Florida statute, which is well-developed and closely mirrors Ohio's.
Identical?
What? I'm sorry, can you
The
repeat that?
Florida statute identical to Ohio's statute?
They are not identical, but they closely mirror each other. Ohio has a separate or an extra subsection that Florida's statute does not.
Why should the court have not held a hearing?
The pre-evidentiary
Yes.
hearing? If you look to the Florida case, Dennis v. State, there was a similar situation that sets a precedent for this case, which where they could have held a pre-evidentiary hearing, but they did not, and it was ruled as harmless error because of the fact that the appellant could not prove that he would have brought any new evidence or new arguments forward at the pre-evidentiary trial.
But Florida law is not precedent for us, correct?
No, it is not. But considering that the Ohio statute is new, it has not been tested as often and as much as the Florida statute has, and we do not have as many cases to look through to help represent the cases as we do with Florida's, with Ohio's. Now, we are not bound to use Florida's statute, but it is recommended to look at it because there are more cases and it has been tested more than Ohio's.
And this may be a circular question, but if we never let a defendant have the preliminary hearing, how do we ever know whether he could have prevailed?
The appellant never made it evident that he would have brought forth any new evidence or any new arguments in the pre-evidentiary hearing.
Was there a hearing on whether or not to have the hearing? And was he required to present some of what he might bring forward at the real hearing or the actual stand your ground hearing? Or did the judge just decide?
It was the responsibility of the appellant side to allow or to inform them if he would have brought any new evidence forth or any new arguments forth in a pre-evidentiary hearing. It is also, to conclude, we ask that the decision of the lower court be upheld, and if there are no more questions, I would like to thank you for your time.
Any further questions?
No.
No, Judge.
Thank you. Any rebuttal?
Your Honors, may it please the Court. The Fourth Amendment does not apply because none of the exigent circumstances existed. We submit that the appellant was in a secure place, so they could not search the iPad. Arizona versus Grant allows for the iPad to be removed but not searched. The appellant's iPad has a heightened privacy, and the law must obtain a search warrant to seek evidence from it.
Well, let me ask on that. You said the iPad could be held but not searched, correct?
Just according to Grant,
Gant.
sorry.
Yeah, that's okay. Now, but doesn't that mean that all this is moot because they could have gotten a search warrant later and this is all a academic exercise?
No, because his privacy was actually violated, and they needed a search warrant to seek evidence because he could have more private information than the cops were looking for on his iPad. May I proceed?
Please.
The police had no reason to search the document My List. It could have been any list, and it's not reasonable to think that it could be a hit list when they are searching through the iPad. There was nothing immediately connected to the iPad during the crime at hand. Looking at the Stand Your Ground incident, they could not determine with the weather conditions that night that if whether or not it was dark and there was limited light. So it was reasonable for the appellant to believe that just because he was wearing a ski mask and screamed, "Hey, you," that there was enough fear to think that he was going to harm him, especially since he was carrying a show snivel. The appellee's argument that he just shouted, "Hey, you," as a friendly comment is invalid because the state admitted that he aggressively shouted this. They also admitted that the circumstances in which Charleston was placed was frightening. We cannot turn to Dennis versus Florida for precedent because this is a case of first impression. And we respectfully request at this time that the trial court decision be reversed. Thank you.
Any further questions?
No.
Thank you. We will now be in recess. The other two judges will go to conference, and I will join them in 3 minutes. First of all, thank you. You can relax a little bit before the next round. We're just going to give you a few comments, and we'll go from there.
First of all, good job. You're done. You got your first one done. That's the hardest one. Just a few things that really can apply to all four of you. Try to, I know you're nervous up there, especially you might get rattled by a question, but when you do answer questions from the judges, answer first before you say anything else, "Yes, Your Honor," "No, Your Honor," or "Could you please repeat the question, Your Honor?" Make sure you're very respectful of the court, and the yes and the no answers the question right away before you kind of navigate back and forth and try to argue your point. Give us a clear yes or no response if that's what the question asks for. There was one point where I think my colleague on the end asked if it was reasonable to concede whether or not Mr. Charleston if it was reasonable to be scared by the victim in the ski mask. Sometimes it's better to just concede a point that's reasonable to concede instead of trying to fight an argument that really, yes, it made sense that he didn't know who the person was in the ski mask. Do you understand? Okay. You both teams at certain points also brought up anticipated counter arguments, but that on the appellant side that you expected the other team to make, and your team mentioned arguments that the appellant had already made, which is good. You're anticipating what the other side is going to argue and coming up with counter arguments to it, which is helpful for the court. And I'll stop now and let the rest of you, and if I have anything else.
Oh. Just a couple points. One, just mentioned, but you're not the only ones. I want to tell you, lawyers get this wrong all the time. Never deny the undeniable. That's what you were talking about with. If you need to concede something, if it's something that's debatable, debate it. But if it's something that is undeniable, don't deny it because you lose credibility. Okay. And at the beginning, you're all nervous a little bit, so this first round, you can say, "May it please the court." You just have to say it once, okay? You don't need to ask me to proceed every time. Just, did I answer your question, Your Honor, is another way to do that instead. But it's a good way to find out, did you answer the question? But instead, I would phrase it that way instead of it's okay to proceed. I forget your first name. Kaylee. You were doing fine, and at one point you got flustered a little bit, and you looked at your partner and you kind of go, "Don't do that." But that's okay, first round, because you got 3 more rounds or whatever to go today. Just, you don't want to ever concede that, okay? that you're flustered a little bit. The other thing is, if don't use this very often, but occasionally, if you need a second to think about a response and you think it's crucial, say, Judge, could you repeat that? And use that time to think about it, okay? I wouldn't use it more than once in an argument, but it gives you an extra 5-10 seconds. And by the judge repeating the question also helps you think about it, okay? Other than that, just all of the eye contact was good. But when we were asked a question, sometimes you would either roll eyes up or down. You don't need to do that. Judges aren't there to make, unlike on TV, judges aren't there to make fun of you or insult you. They're just trying to get information. And so they're actually very nice to you most of the time. Not all the time, but most of the time. But I thought it was very good, and I, especially for an opening round, I think it was very good.
I was very impressed with your demeanor and your preparedness. Obviously, this is the first time this has been done, so you didn't have anybody to learn from, or students a grade ahead of you to have watched them. So I think you did an excellent job. One of the things that stood out for me was how well you knew the case law. You really did. And you're going to lose face no way faster in front of a judge if you get up there and misquote a cite or kind of make up your own little facts to make it work for you. And none of you did that. Again, to add on to the point that's been made, and not that this was the worst thing that happened, but there really isn't a legitimate argument that a guy with a shovel, and there's no way he knew it was plastic, at nighttime, running towards you in a ski mask, yelling, doesn't frighten you. I mean, that's something you should have conceded. But, Your Honor, was his reaction legal? That's what you want to argue. Don't pick nits over whether or not he had any reason to be scared. But I thought all of your arguments were very well reasoned. And again, I was so impressed by your knowledge of the law. Because while the facts from the lower courts are the truth, you still can put your perspective on the truth. You can't do that with the law. You have to stick with what you can argue that the law fits your facts, but you can't change the law. So I was very impressed with how well you knew it and used it. So good luck.
Do you have any questions of us? It's unusual for a judge to ask, do you have any questions? But this is a learning experience for you all, so it's important.